All right, I think I'm going to get us started. My name is Carol Levine, and I have the privilege and honor of chairing Courts Matter Illinois. I'm proud to have been a part of that organization since its founding. I'm getting a question about getting a group screen. Let me see if we can do that. Does that help? I'm not sure. Let's see. I'm not sure if we can get a speaker view. Mike, can you check and see if we can get the speaker view on the screen?
Did that fix it?
I'm not sure. Let's check in the chat box. So that the person who's talking is the one on the screen. Let me do it while we're working on that. Let me, because I know you can hear me, let me do a few little housekeeping items. All of your microphones and your cameras, those of you who are participating, are turned off. You'll be able to see and hear our speakers. We would ask that you put any questions you have during this webinar in the Q&A box. You can find that at the bottom of your screen. It's marked Q&A. And that any comments you have, that you put those in the chat box. So comments in the chat box, Q&A and questions in the Q&A box. And before we officially begin, I want to thank a few people. Particularly, we have a number of organizations that have sponsored our entire series, Courts Matter, to the 2020 elections. Those sponsoring organizations are Chicago Women Take Action, National Council of Jewish Women, Chicago North Shore and South Cook, National Council of Jewish Women State Policy Committee, Planned Parenthood of Illinois, the American Constitution Society of Illinois, National Employment Lawyers Association of Illinois, and the Citizen Advocacy Center. I also want to say a big thank you to the organizations that are home bases for our expert speakers today: the Illinois Coalition for Immigrant and Refugee Rights, Heartland Alliance's National Immigrant Justice Center, and the law firm of Minsky, McCormick, and Halligan, who have generously given us the time and expertise of members of their staff. Now, for those of you who are new to Courts Matter Illinois, I want to give you a little bit of background information on just who we are and what we do. And this will be a very short bit of information. We are a coalition of organizations and individuals working to ensure a federal judiciary that's comprised of judges who are committed to upholding core constitutional values. Now, core constitutional values include such things as voting and civil rights, workers' rights, freedom of speech, the separation of church and state, and the right to privacy, among other things. Here's some of the things that we do. We work to educate the public and our elected officials about the importance of the federal judges who sit on the U.S. District, Circuit, and Supreme Courts. So education is a primary function of what Courts Matter Illinois does. We provide information to the community about the judicial nominations process and the judicial nominees who will impact our constitutional and fundamental rights. We support a judicial nomination process that is fair, identifies well-qualified and diverse, unbiased, nonpartisan nominees. We mobilize our communities to speak out and take action on federal judicial vacancies and on issues that affect the federal judiciary. Courts Matter Illinois monitors and takes action to ensure fair consideration of federal judicial nominations because of the immense power held by the individuals who hold lifetime seats on the federal courts. Now, I'm going to take 5 minutes to explain the federal judicial process, and I promise you it will only take 5 minutes. So, Mike, if you can screen share, and I'm going to move this so I can see the screen. Let me do one thing. Let me do that. Okay, so here we go with Federal Courts 101. Next slide. Okay, the federal courts are made up of 3 branches. Most of you may or may not know this. You all know about the Supreme Court with its 9 justices. Then there are the U.S. appellate courts. These hear appeals that come from the other branch of the federal judiciary, the district courts. So the district courts are the largest number. There are 686 district judgeships. The appeals courts, there are 179 seats. And then we go back up to the Supreme Court with 9 justices. The Supreme Court, which most everyone knows about, hears only between 80 and 100 cases a year. They are asked to hear over 7,000 cases. So think about that in the context of how many cases there could be. Next slide. Okay, this will give you a sense of where all these courts are. Illinois sits in the 7th district. You can see us right there in the middle. There are 3 states in the 7th district: Illinois, Wisconsin, and Indiana. If you look around, you can see that there are some districts that are quite huge, like the 9th district out west. You hear a lot about that one. The federal courts, if you look over to the right, heard over 400,000 cases, and that was back in 2018. So compare that to the around 90 to 100 cases heard by the Supreme Court, and try to understand where the laws actually get made and decided. Next slide. This is how the former nomination process worked. Now, I say that because it's not the way it works today. It used to be when there was a vacancy on an appellate or a district court, the President of the United States would consult with the home state senators for a candidate recommendations. Then those recommendations would be vetted by the White House and a nomination formally announced by the White House. And the home state senators would then return a blue slip, a piece of paper that was blue, saying, yep, we agree, you should nominate this guy, and he should have a hearing in the Senate Judiciary Committee. If the Judiciary Committee said yes, then that nominee was sent to the floor of the Senate for a vote by the full Senate. That's how it used to work. Let's go to the next slide. Now, when a vacancy is created, the president consults usually with the Heritage Foundation, the Federalist Society, and other right-wing organizations, but not necessarily the home state senators. The candidate is then vetted by the White House. The nomination is formally announced by the White House. And for the most part, blue slips are ignored. Once in a while, we hear about a blue slip, but not often anymore. The nomination goes to the Senate Judiciary Committee. Hearings are generally rushed. Some are what they've begun to call stacked, which means you have multiple hearings at one time. Members of the committee may get up to 5 minutes to question a nominee. A yes vote sends the nominee to the Senate floor for a confirmation vote. When talking to staffers who work on the Judiciary Committee, they've often called this process the rocket docket, which means that's how rapid things happen in this process. Go to the next slide, please. On the Senate floor, the traditional process that allowed for debate on judicial candidates on the Senate floor, often up to 30 hours of debate, or even a filibuster of a nominee, were set aside at the end of the Obama administration. The majority leader of the Senate can now call for a vote with limited time for debate. That time is 2 hours. 2 hours for a lifetime appointment. And it only takes a simple majority to confirm a judge for a lifetime appointment. And with one party holding the majority of seats in the Senate, votes on these nominees are often along party lines. Next slide. Next slide. Okay, this is just a slide that was put out. It used to be that the American Bar Association would rate the nominees, and it was rare that a nominee was rated not qualified. In the last 3 years, and this is a slide from 2 years ago, we have seen more not qualified nominees coming forward than in any other time combined, often because they are younger, they have less experience, they are very biased on certain areas, particularly around the issues of LGBTQ rights, abortion, voting rights, and even to saying that the issue of Brown v. Board of Education, which said separate but equal is not okay, they will not say that was rightly decided. And that was a unanimous decision by the Supreme Court. Next slide. So here's the question. What can you do? Well, first, you should be paying attention. Second, you should be raising awareness about the federal judiciary, not just the Supreme Court, but the appellate and the district courts. Third, when there is a nominee who is not qualified, you should be calling your senator and saying, you should vote no on this nominee. Third and fourth, you should be educating others. And the last thing you should do is you should vote. You should vote for senators and other elected officials who care about the judiciary. Next slide. That's it. That's the end of the show. So I am now going to introduce the moderator for our panel. Let me just see, there were a couple questions in the chat box. I just want to make sure I cover them. Okay, I think we're okay on the questions. Okay, so I'm now going to introduce David Melton, who is going to moderate our panel, and then I'm going to stop talking. So David Melton is a semi-retired attorney. He's one of the busiest people I know, however, who graduated from the University of Wisconsin-Madison with an undergraduate degree in history and from the University of Chicago Law School with a JD degree in 1977. He began his initial 10 years in practice focusing mainly on commercial litigation before shifting his attention to intellectual property litigation, consisting mainly of patent and trade secret cases. Over the last 25 years of his career, which he spent at large Chicago and national law firms, he has largely retired from active practice of law in 2009, but remains active in bar associations and law reform efforts in the area of campaign finance reform and election law, civil liberties, including police oversight, federal courts, and intellectual properties. He worked on a number of pro bono cases in these areas while in practice and continues to be active in those areas as co-chair of the Chicago Council of Lawyers Civil Liberties Committee and a board member of Reform for Illinois and the Chicago Justice Project. And David is also a member of the steering committee of Courts Matter Illinois. David lives in Evanston with his wife Nancy, and that's where they raise their 2 kids. So David, it's my pleasure to turn this over to you, and I'm going to go off mic and off screen.
Thank you very much, Carol. Before I introduce our panelists today, I'd like to take a couple minutes just to tell you about or remind you of several cases that we identified in our flyer for this program and bring you up to date on a few recent developments in those cases. We identified 4 cases in the flyer. The first of those cases was a case known as Trump versus Hawaii, which concerned the ban on immigration from certain Muslim countries that President Trump promised to impose a ban on during the last presidential campaign. As you know, he instituted such a ban shortly after his administration took office in 2017. You may recall that after several bungled and revised attempts, the administration eventually adopted such a ban. And in the case in question, the U.S. Supreme Court eventually permitted that ban on immigration from certain Muslim countries to stand, with a bare majority of the court choosing to ignore the president's prior stated reasons for the ban and instead accepting a belated revised rationale for the ban. As far as I know, that ban still stands. The second of the cases that we identified is known as the Department of Homeland Security versus Regents for the University of California. And it concerned the administration's efforts to end the program known as DACA. As you probably know, DACA is the program that the Obama administration instituted to try and protect people who had been brought to this country as children and give them a path to citizenship. This administration, through the Department of Homeland Security, had declared that the DACA program was illegal, and it had sought to end it. As you may also recall, last month, the Supreme Court invalidated that effort to strike down DACA, finding that the government had not followed the proper procedures for making major changes to such a program. However, it's important to keep in mind that the DACA program remains at risk because the administration could eliminate it at any time by way of an executive order or by having the Department of Homeland Security reinstitute efforts to eliminate the program. The third of the cases that we identified in the flyer was Wolf versus Cook County, which I think one of our panelists, Fred Tsao, participated in through ICER, and involves an effort by this administration to deny immigration requests if the immigrant has taken advantage of any program intended to help lower income people in this country. And it does so by seeking to greatly and unrealistically expand the definition of who constitutes what's known as a public charge in the immigration statute. The lower courts had prohibited the use of that broadened definition while the case proceeded, but a bare majority of the Supreme Court stepped in to lift that prohibition in a February order earlier this year. The case, however, continues to proceed through the lower courts, and last month, the Seventh Circuit Court of Appeals here in Chicago ruled that the broadened definition of who constitutes a public charge was improper, and it upheld the preliminary injunction entered by the trial court. It's likely that the administration will file an appeal to the Supreme Court, but in the meantime, the administration continues to use the improper definition to deny immigrants their rights because of the Supreme Court's February order in the case barring injunctive relief while the case proceeds through the courts. The fourth and final of those cases is Barr versus East Bay Sanctuary Covenant, which concerns this administration's efforts to deny asylum in this country to immigrants fleeing violence and other threats. The administration seeks to do so in two ways. First, by changing the definition of who qualifies by asylum, by, among other things, eliminating, for instance, the threats from gangs in Central American countries as legitimate bases for seeking asylum. And second, by requiring asylum applicants who pass through another country before reaching the United States to first have sought asylum in that country that they pass through, and requiring asylum applicants to await a hearing on their asylum petition here in those other countries, which is primarily awaiting asylum hearings in Mexico. And those delays for those hearings are now very extended. Once again, in the litigation, the lower courts have prohibited the government from making the changes while the litigation was pending. But again, a bare majority of the Supreme Court stepped in to lift that injunction last fall over the strong objection of Justice Sotomayor, which thereby permitted the administration to follow its destructive policy while the litigation proceeds. Last week, a panel of the Ninth Circuit Court of Appeals, where the case is pending, ruled that the administration's proposed limitations on asylum applicants passing through third countries were illegal. The case does not address currently the administration's proposed change in the definition of who is entitled to seek asylum on the basis of threats they face in their home countries. Presumably, the administration will seek to appeal the decision of the Ninth Circuit last week to the Supreme Court. However, in light of the Supreme Court's earlier decision prohibiting injunctive relief while the case is pending, the administration again continues to adhere to its illegal limitations on asylum applicants, literally putting many of those applicants' lives in danger while they wait for the hearings in Mexico. Now, these four cases illustrate for outsiders like me the problems with our immigration system that this administration has greatly exacerbated. However, the three panelists that we've asked to participate today get to see these problems on a much more intimate and frequent basis, working in the system as they do on a daily basis. So let me now briefly introduce those panelists before turning the program over to them. The first of our panelists is Fred Tsao, who is Senior Policy Counsel at the Illinois Coalition for Immigrant and Refugee Rights, which I'll refer to as ICER. In this position, he provides technical support, trainings, and presentations on immigration-related topics to service providers, immigrant community organizations, and others who work with immigrants. He also provides updates and analysis of changes in immigration policies and procedures to ICER members and allies, and assists with the coalition's legislative advocacy efforts. Describing himself as a, quote, recovering attorney, Fred practiced law originally at the Rockford office of Prairie State Legal Services, where he worked after receiving his law degree from the University of Michigan. He's also worked with the American Civil Liberties Union of Illinois, the Chicago Anti-Hunger Federation, and the Missouri Public Interest Research Group. A native of Chicago, Fred is the son of immigrants from China, and he's had a lifelong concern with immigration issues. Meg McCarthy is the executive director of the Heartland Alliance's National Immigrant Justice Center, one of the nation's leading immigrant and human rights advocacy organizations. Under Meg's leadership, NIJC has become a leading immigrant and human rights advocacy organization and has contributed to national and international analysis, debate, and reform of immigration law, policy, and practices. She's built a network of over 1,500 pro bono attorneys who are essential to providing legal services to thousands of individuals each year related to immigration issues. An expert in immigration law, Mary Meg has testified before Congress, is quoted often in major news outlets such as MSNBC, the New York Times, and Chicago Tribune. Prior to joining NIJC, she practiced civil litigation and was an NIJC pro bono attorney. Earlier in her career, she worked in local communities in Chile to help safeguard the rights of individuals under a dictatorship. Mary Meg has been honored with several awards, including the American Constitution Society, Chicago Lawyer Chapter Ruth Goldman Award, the Chicago Inn of Court Don Hubert Public Service Award, the Pax Christi 2003 Teacher of Peace Award, and the Damon Award from Loyola University. Our third panelist, Judge Robert Vinikoor, served for 30 years as an immigration judge in the U.S. immigration system. He retired from the bench in 2017 and has joined the firm of Minsky, McCormick, and Halligan, a Chicago firm. Judge Vinikoor was appointed as an immigration judge in January of 1984. During his long tenure on the immigration bench, Judge Vinikoor has authored numerous precedent-deciding cases covering topics such as crimes involving moral turpitude, aggravated felony offenses, frauds committed at the time of entry and or adjustment, and claims to U.S. citizenship. During the past 30 years, Judge Vinikoor has heard evidence in asylum cases from around the world. His decisions have led to a better understanding of the scope and evidence needed to qualify as a refugee under the Immigration and Nationality Act. And upon his retirement from the bench, he was the second most senior immigration judge in the country. Prior to becoming an immigration judge, he had been selected under the Department of Justice Honors Program and started his employment with the Department of Justice in 1976 as a nationality attorney with the former Immigration and Naturalization Service in Miami, Florida. From 1978 to 82, he had served as a trial attorney in Chicago, and in 1984, he was appointed as a special assistant in the U.S. Attorney's Office in Chicago. He then took the bench beginning in 1984. Judge Vinikoor has been a frequent lecturer and guest speaker on numerous immigration topics at Bar Association meetings, at continuing legal education seminars, and law school programs. He's also taught new judges at the National Judicial College in Reno, Nevada, and he currently serves as an adjunct professor at Loyola University School of Law in Chicago, teaching immigration law. So with that introduction, it is now my great privilege and honor to turn this discussion over to the three panelists. And I would ask them to begin by just telling us not only why they care about this topic, but why they think the rest of us should also care about this topic.
Great. Well, I'll begin. I think it's really important what we're discussing today in terms of the importance of the federal courts in the immigration context. As many of you may or may not know, the immigration courts in the United States are administrative courts within the executive branch. And immigration is considered almost exclusively a civil matter. So as a result, individuals facing deportation don't have the safeguards that most people have in the judicial system. They don't have a right to a jury trial. They don't have a right to court-appointed counsel, a right to bail, a right to Fourth Amendment protections against illegally gathered evidence, or the right to protection from ex post facto laws. So access to the federal courts is the last line of defense for individuals facing things like torture, murder, permanent separation from their families, in addition to more mundane things such as standing to lose a job, a mortgage, community of friends. They are an essential part of our democracy, the courts, and in the immigration context, they are critical to ensuring that the administration, which has very broad powers in the immigration context, is upholding constitutional and statutory rights, including under the Administrative Procedure Act, which we'll probably be talking about in some of the context of these cases. Now more than ever, this branch of our three branches of government is really critical. We have an administration that often does not uphold the Constitution and apply the laws. We are seeking court intervention more than ever before. Since the first days of this administration, which David mentioned with the refugee or the Muslim ban in 2017 to last week, when the administration announced that it was restricting access to higher education for foreign students unless they were taking classes in person. The courts have been the only guardrail available and the last line of defense of human rights and due process. We haven't always won, but there will be significant rebuilding work to be done. But the courts have held off and struck down some of the horrible things that this administration has attempted to implement. And we can talk more about that. But I think this is a really important discussion, and the federal courts are so critical to our work right now.
Go ahead, Fred.
Okay. Thanks, Mary Meg. It's kind of hard to follow what you just said, especially since I was going to say many of the same things. I think it's important to note that immigration processing is a process, and while many people who may be, say, applying for a visa or applying for a green card or applying for citizenship may not have any contact with the courts, every person applying for asylum, every person who's going through deportation goes through a judicial process. As Mary Meg mentioned, it is an administrative process as opposed to the Article 3 courts that Carol laid out in her introduction. But that said, many of those cases do end up getting appealed further to the circuit courts and in some cases even to the Supreme Court. So in that respect, courts are vitally important when it comes to determining our deportation policies or our asylum laws or many of the other affirmative policies that our nation sets forth. But I do want to particularly emphasize the point that where Mary Meg ended, which is that in addition to being a source of review for many of the administrative policies that are procedures that are involved in immigration, the courts are also a major and very crucial and these days vital backstop against abuses by the other branches of government, and particular by this administration, in putting a halt, at least in many cases temporarily, in some cases permanently, to many of the policies that ICE or U.S. Citizenship and Immigration Services or other people in Homeland Security or the Justice Department for that matter may be trying to impose unilaterally. Many of the challenges to these policies have been under the Administrative Procedures Act, which got mentioned earlier, but many of them have also cited just really bedrock principles of our constitutional law, whether it's equal protection or due process. Where else can we really turn? If we see a policy that is not only just unfair, but also really damaging to hundreds of thousands of people, as was the case with DACA. So these days in particular, courts do matter.
I would add my comments to that. I was appointed a long time ago by William French Smith to the Immigration Court bench. That was probably before many of you were born. In any event, the Immigration Court is an administrative court, but independent under the Attorney General within the Department of Justice. As an immigration judge, I had no reservations about reaching a decision. I did not have interference from my chief judge or the Attorney General. And I felt completely free to enter my interpretation of the immigration statutes to a particular case. Unfortunately, in the last 3.5 years, the independence of this administrative court has been completely eroded. The Attorney General and even the Board of Immigration Appeals that sits as an appellate court above the judges has narrowed the practices of the immigration judges and taken away a lot of the due process rights of the individuals who appear in front of them. So the immigration judges' hands are tied as to what relief they can grant these individuals, in part or mostly due to policies of this administration. It's never happened before to this extent. This administration has put quotas on judges. It's unheard of to require judges to decide X amount of cases per year or face employment consequences. So this pressure is coming down from the executive branch because immigration falls within the immigration branch. The judicial branch, which is Article 3, is the only check and balance on the executive branch. And now that I'm in private practice, I can tell you that I filed in federal district court, I filed in the Court of Appeals here in the Seventh Circuit, where I felt that my client was not being treated fairly. Now, whether it was at the immigration judge level, I had one case, which I'm not going to discuss the particulars, but a departure order was entered on, or I felt unfairly. I filed an appeal. It sat at the Board of Immigration Appeals for a year and a half, and they dismissed it in a one-line opinion saying that the immigration judge's opinion is upheld. We're not issuing an opinion. Now, the administration has allowed the Board of Immigration Appeals not even to review the merits of an appeal from an immigration judge, and for expediency's sake, to simply say, we're not issuing a decision. I filed a petition with the Court of Appeals. The government attorney representing the Department of Justice immediately saw what the issues were, and the case was immediately reopened and sent back to the immigration court. So the point I'm making really is that courts matter. We need, because the administrative court is being narrowed, the judge's authority and independence is being limited, we need the federal courts to step in. And we may talk a little bit later, if we have more time, some recent decisions that had come out of the federal court that have now rolled back some of the executive branch decisions. Mm-hmm. So it's very, very important.
Well, that's a perfect segue, Bob, to let's talk about some of those decisions. Why don't we go in reverse order? And why don't you each take a minute to talk about some of the important decisions that you've seen, or important precedents that you see in the system and what's going on with them?
Well, I would just mention some very recent decisions that have come out of the federal courts. The immigration judges were supposed to be independent and have the authority to control their dockets. What is a priority case? What case could be continued indefinitely while some other relief is being worked on? It was called continuances or administrative closure. The judges always had the authority to control their docket. A few years ago, I think it was in 2018, the Attorney General issued an opinion. The Attorney General issued an opinion in an immigration case saying the judges could no longer continue cases or administratively close cases while the person in front of the court sought other relief. They were married to a citizen, they were a victim of a crime, were seeking a U visa. So normally the judges would have authority to prioritize their time. Well, guess what? Last week, and I don't know if the National Immigrant Justice Center was involved in this case, Morales versus Barr, the Seventh Circuit in a unanimous decision found that the immigration court and judges had broad discretion to control their own dockets and overturned the Attorney General's opinion where he eliminated the judge's authority to administratively close or continue cases for alternative relief. Now, that case dealt with a victim of a crime who was qualifying for a visa to remain in the U.S., but the immigration judge said, I can't grant you a continuance. I have to enter a departure order. And the Court of Appeals found that that was unfair, that Congress stated that people who are victims of crimes who have cooperated with law enforcement should be able to remain with their visas and not face removal. And it was a startling opinion by the Seventh Circuit Court of Appeals. Another case that I work with, National Immigrant Justice Center and a private firm, was a case under the Trafficking Victims Protection Reauthorization Act that was decided in June as well, where a federal court, district court judge, Contreras, issued a 180-page decision finding that the practice of immigration, taking these unaccompanied minor children into custody as soon as they turned 18 years of age, was inconsistent with the statute. The statute said that when an unaccompanied minor who's here in the United States in Office of Refugee Resettlement custody turns 18, they should be placed in the least restrictive setting, but immigration was not following that. And it took a federal court to step in, first entering a preliminary injunction and then a final injunction saying, immigration, you must file the statute. So these are two recent decisions where the federal courts have stepped in and say, let's go, executive branch, you're not following the law. So those are just two examples.
Those are very interesting examples. Fred, do you want to pick up on that and talk about some cases that you've been, some recent or significant cases that you've been involved in?
Well, I was actually going to go to the other end of the telescope and talk about some of the historical context for courts being involved in immigration policy, and I'll try to do this very succinctly. I think it's important to note that some of the earliest court decisions regarding immigration had to do with the Chinese Exclusion Acts back in the 1880s. And, this was a very different time in our country's history with very different attitudes toward immigrants, toward people of color. And back in the 1880s, the Supreme Court went out of its way to uphold many of these expressly discriminatory laws that were passed by Congress that essentially barred Chinese laborers from coming to the United States. And I don't just say this because I'm a person of Chinese descent, but these are cases that pretty much set the tone for much of immigration policy basically ever since then. And in particular, the Supreme Court took an interesting tack of saying that, as a sovereign nation, the federal government has what's called plenary power to do what it wants to with respect to immigration. And we've seen this play in over and over again, and this doctrine being cited over and over again in the decades since. And one could even see the lineage of this play out in cases like Trump versus Hawaii, the travel ban cases. Where does the administration get its power? Well, there was a specific citation to a specific piece of the statute, but really that the basis of that statute is in the plenary power doctrine. At the same time, kind of running parallel and interwoven into this is a recognition by the courts of certain basic constitutional rights, and including things like equal protection and due process. And I'll just mention one case in particular, there's that Zedvitas case, which the Supreme Court ruled on back in Mary Meg or Judge Vinikoor, help me, 2002, was it? 2001, it was pre 9/11. That basically said that people who were, people who were maintained in immigration detention, who could, for whatever reason, could not be removed, had the right to request review of their conditions of detention. And if if the immigration authorities could not establish the justification for maintaining this person in detention, these individuals needed to be released. Now, obviously, there's been a lot of controversy, and Mary Meg, you can fill in the details on this regarding the implementation of this decision, but this is a decision that is on the books. And it's pretty interesting that we are seeing, that at the same time that the Supreme Court has given the federal government a wide berth with respect to what it could do on immigration, it has also set limits on, precisely on what the federal government can do within the strictures of the U.S. Constitution.
Well, it is good to hear that there is some reason for hope, at least over the long term, in terms of progress at the Supreme Court, some progress at the Supreme Court level. Mayor Meg, you want to pick up on that?
Yeah, I mean, let me just move forward a little bit in time from where Fred ended up. In 2018, we had another major victory at the Supreme Court, kind of following the line of Zydvitas, not about detention, but about what constitutes what's called an aggravated felony in the immigration context. And in that decision, the court found that that term, aggravated felony, was unconstitutionally vague and that due process demands specificity. It was a really, I would argue, a groundbreaking case in the sense that it overturned a part of the law which impacted thousands of individuals who've already been deported, unfortunately. But Justice Kagan reiterated in that decision that deportation is a drastic measure, often amounting to a life banishment or exile, and reference a 1948 case. And in her decision, she says, thus, deportation demands the highest standard of due process. And I think we really have to hold on to that. And interesting enough, Justice Gorsuch in that case argued that once you give someone property or status, like granting lawful permanent resident status, they're entitled to corollary rights, regardless of the intent. And in that case, the status amounts to a kind of liberty, and the Constitution protects against arbitrary deprivation of liberty. And where the court found due process, it looked at the constitutional aspects and has the government met its constitutional burden to the person, not to the alien. So I think it's really important that when we think about the courts, when we argue before the courts, that we set aside the statutory interpretations of immigration law and what's the issue with respect to an alien, but look at the person themselves and think of persons before the law. Don't pull in the cultural issues or should they or shouldn't they be deported, how many people should be in our country, but what's that human being's right under our Constitution? And I think that was a really groundbreaking case. I just want to say another point. I think it's really important to note, like you referenced, David, the DACA case. The administration screwed up. The administration just can't do what it wants. And I think that was really important. And like the DiMaia case, the court said, look, you've given certain rights to these DACA recipients. And if you're going to strip that and terminate that, you have to do that in the right process, in the right manner. And I think, again, it was illustrative of the administration just, saying, well, you know what, we're going to end it and we're going to just do it our way. And you can't do it that way. And I think that was the same thing with some of the asylum cases that we've seen that Judge Vinikoor and that you mentioned also, David. They've implemented these bans against asylum at the border, and we've been litigating those cases. And oftentimes, the most recent decision, the court said, hey, you didn't follow the notice and comment period as required under the Administrative Procedure Act. The policy is vacated. And that's really important, that we just keep fighting in the courts and saying, you have to do the right thing. And I have to note that Judge Vinikoor was our expert in that case with respect to unaccompanied immigrant children. And it's been really important in these cases that we develop really strong records and the evidence to show the courts how what the administration has been doing is illegal. And then lastly, Judge Vinikoor mentioned the case regarding the prohibition on immigration judges. And that's been something we have been fighting at the National Immigrant Justice Center. And my colleague Chuck Roth argued that case that Judge Vinikoor mentioned. And it's just another example of the court telling the administration that because you say so, it's not legal justification for misinterpreting a statute and ignoring precedent. And interesting enough, that decision was written by a Trump appointee. So we just have to keep using the courts in the immigration context. Our litigation team has grown immensely because it's just so important.
Let's talk about, and maybe we should start with you on this, Fred. What have you seen in terms of on the ground, sort of the impact of some of these decisions that we've been talking about, the impact of these changes over the past 3.5 years in the immigration courts?
Okay, so well, I'll talk about two of the cases you specifically mentioned, David, at the outset. Obviously, the DACA decision, was had a very great impact on hundreds and thousands of younger people who have DACA or who may have missed the opportunity to get DACA, but have some hope of being able to apply sometime fairly soon. I know many people who have DACA or who previously had DACA and have found ways to, gain lawful status in other ways. 3 of my colleagues at ICRR are DACA grantees. So, they lived with, years of anxiety basically ever since the 2016 elections, wondering, when the hammer is going to fall on DACA. And, it's only through the intervention of the courts in blocking this administration's attempts to rescind the program that these individuals have been able to, at very least renew their DACA, remain, protected from deportation, remain able to work, remain able to support their families, and move forward with their education and careers. I remember seeing a statistic recently that there are tens of thousands of DACA grantees who are working in healthcare these days. These are the people on the front lines during our current pandemic, and yet this administration is trying to strip these people of their ability to work and to provide the services and use the education that they've developed over the years. So. Obviously, as Mary Meg noted, the Supreme Court, while it did keep DACA in place, it also pointed out that the administration did it the wrong way. The court did not say anything about whether DACA was legal or illegal, or properly put in place or not properly put in place. So DACA is still at risk, and we're seeing with the very slow implementation, the non-existent implementation of the court's decision by Homeland Security, that we're still not out of the woods yet. Let me also briefly mention the public charge case. Wolf versus Cook County. Even though Cook County is kind of the lead plaintiff here, ICRR was a co-plaintiff in that case. And we brought this suit because, this new public charge rule that the administration has basically jammed through is and seems intended to create confusion among many immigrants, including many long-term legal immigrants, as to what kinds of nutritional assistance or medical assistance or financial assistance they're able to apply for themselves or for their children and their families. And the administration itself, when it published its rule, anticipated that there would be worse health outcomes and more use of emergency rooms and more absenteeism from work. This was all anticipated by this administration. They went ahead and issued this rule anyway. So we worked with a number of legal service allies, at the Shriver Center and several pro bono firms to develop legal theories to challenge this rule. We did prevail, at the lower court level, but David, as you noted, the Supreme Court saw fit to set aside the lower court injunctions and to allow this administration to move forward in implementing this rule. So we are. Even before this rule was published, we were already seeing lots of questions and lots of fear in the community. We're very concerned about how this is playing out, particularly in the context of this pandemic, of people being concerned about even seeking COVID testing or treatment for COVID. So this is kind of the bad counterexample of what kind of impact a court decision can have on immigrant communities.
That's a very interesting point, Fred. Let's follow that up a little bit. Judge, do you want to comment about some of the other things the administration has been doing lately that seem to sort of create some confusion as well? Let's talk about the recent announcement of the academy that they're going to run, or the decision that was that Meg had referenced about now disallowing visas to students studying here if none of their classes were being held in person.
Let me start with that one. The United States has millions of foreign students going to school every year. It's wonderful for the United States. It's wonderful for the schools that allow them to attend. They pay out-of-state tuition. It's a financial gain. They're getting training, and many of them remain in the United States and go on to become productive citizens of our country. It's a win-win situation. To be a foreign student, you have to maintain a full course load at a university, and you can take online courses, but you must take at least 3 credit hours of 12 credit hours in classroom. And this hullabaloo comes from that one requirement that foreign students be in the classroom for 1 3-credit course, or otherwise they're not maintaining their non-immigrant status as a student. And if you don't maintain your status, you have to leave the country. Now, in a practical sense, these students are here for advanced degrees, medical degrees, everything, and to be knocked out of status in the middle of their education seems wrong. Why? Because of the pandemic. Why, for our own protection, the schools have said we have to go to online classes. We can't allow in-person classes. But for some unknown reason, the Trump administration, whether it's anti-immigrant policy or just being hard-headed, said, if you don't attend at least 1 class, you're in violation of your student status, you have to leave the country. So as a result of that, all the universities are screaming out and filing lawsuits against the Trump administration, but it doesn't make any sense. We're in the middle of a pandemic. Why require foreign students to attend an in-person class? So I would start with that, and I just don't know what the reasoning behind the administration's position is. And I would be surprised if the federal courts don't come down and say it's totally arbitrary and capricious. But we again have to resort to the courts to put a check on the executive branch. I wanted to make a comment about DACA. We were talking about DACA. it was an executive order by President Obama that decided that in fairness to the children that were brought to the United States by their parents, not on their own, they should be given and have grown up in the United States, given the right to remain in this country. Now, to me, the American public is behind it. Congress, both sides of Congress are behind it. But for political reasons, the administration will not agree to pass legislation that will qualify DACA members to become lawful permanent residents. And it's strictly politics. And so even though the Supreme Court said they didn't like the way the Trump administration terminated it, the Trump administration is now saying they're going to come out and terminate it again. And it's going to place all these people in limbo. And hopefully there'll be legislation in the future that will resolve the status of all these DACA people. What was the issue of what else did you want me to discuss? The trends or?
I think that's good. Why don't we let Mary comment on the other one that I had mentioned, which was this academy. Mary, do you want to explain to people what this is and what's going on as far as we know?
Yeah, this is some initiative by ICE, ERO. ICE is the Immigration Customs Enforcement. ERO stands for Enforcement Removal Office here in Chicago to have what they call a training, 6-week, I believe, training academy, showing members of the community what they do and how they go out and arrest and detain people. And allegedly people will participate in these operations. It's very concerning. Chicago is a sanctuary city, as many of you know. We have really stood up and cared for our neighbors and brothers and sisters who are immigrants. And this seems to be breeding white supremacy and racism. Our concern is that this should not move forward. This should stop. It's not helping our communities, particularly given what we've all gone through the past couple of months and the death and murder of George Floyd. Like, it just screams of racism, and we should stop it right now. I would just like to raise one other point about impact that you raised, David. I think it's really important to remember what's happening to asylum seekers today. They are facing an uphill battle. We have always welcomed refugees and asylum seekers into this country, and this administration is trying every which way to destroy that process. And these are people who are fleeing for their lives, fleeing torture, fleeing persecution. And not only are we fighting this in the courts, but we also have to fight this with the administration that has recently proposed regulations to essentially eliminate our asylum process. This is a system, the Refugee Act, under international and domestic law that is globally recognized, and this administration is trying to end it. So the proposed regulations are out. The administration has given us only 30 days to comment, but it's really important that people who are part of today's program realize that we have to fight to protect.
Why don't you just briefly, as I understand it, Mary, the deadline for comments on that proposed regulation is tomorrow. So tomorrow's the last day that comments can be put in.
Right.
And I believe we will be making available through the chat box here, we'll list a site that you've given us where people can use to put in comments on that proposed regulation. Judge Vinikoor and Fred, why don't you expand on Mary's comments about basically what's going on with the asylum system? and has been going on for the past several years.
I'll just make a few comments, and then Fred, you could speak on the topic as well. The United States joined the United Nations Protocol for the Protection of Refugees. We signed on to the United Nations Protocol in 1967. And in 1980, we passed the Immigration Nationality Act defining who a refugee is and what constitutes persecution. And a person that's fleeing persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion, or fears persecution for one of those reasons, can qualify to remain in the United States and become a lawful permanent resident. Thousands of people apply for this every year, whether they approach the border and say, I'm fleeing persecution, whether they arrive with visas and express their fear at the airports. And there's been an orderly process to allow these individuals to have their day in court, to present their cases to the immigration judge, to try and retain an attorney to represent them. And it's not an easy process because, one, you have to show you fear the harm on account of one of those grounds. Two, the harm that you fear normally has to be from the government or someone the government is unwilling or unable to control. You also have to show you can't relocate within your country to avoid the harm. So there's a lot to the asylum process. Well, with this proposed regulation, the government is essentially eviscerating or eliminating a person's right to apply. They are narrowing the definition of who could apply and what type of harm qualifies as persecution. And now they require extremely serious or imminent harm to say that you've been persecuted. They have also cut out a person's day in court. If you don't articulate a claim, you're not even entitled to a hearing. Now, I'm just mentioning 2 out of 10 or 12 or 14 restrictions, but I might add a personal note. I'm representing someone who had a 9-minute hearing before an immigration judge. He was here as a refugee from Ethiopia and had lived in the country for 30 years. He was convicted of a crime. The judge talked to him for all of 9 minutes and said he didn't qualify to reapply for asylum, withholding of removal, or torture convention protection, and immediately ordered him deported and terminated his resident status after 30 years. And I took that case to the Board of Immigration Appeals, and even though he's in custody, and it's now 8 months later, they have not issued a ruling. And here's a judge who I think, for the purpose of expediency, said, I'm not going to allow you to present your case, immediately ordered him deported. And that's what these regulations propose. They're making asylum officers and judges like gatekeepers. I don't like what your argument is, you don't even get a hearing. So everyone who's attending the conference today should file some type of response to these regulations, how unfair they are. So Fred, why don't you comment as well?
Okay. I will just briefly note that, the proposed rule goes so far as to say that someone could be denied asylum or withholding if they're late on their taxes. What does that have to do with anybody's claim for humanitarian relief? But yet there it is in serif type in the draft regulations. I would echo what the judge and Mary Meg just said. These regulations are outrageous. Unfortunately, they are of a piece with basically everything else that this administration has done to try to, clamp down on immigration one way or another. The asylum process being just, if anything, just the tip of the iceberg, and the way that people are being treated at the southern border with respect to, metering and family detention and separations, but also keeping in mind things like things like the travel bans, things like the shutdown of refugee resettlement, the attempts to, the attempt to do away with DACA, the attempts, the various, proposals, to try to gut family-based immigration, and now basically, imposing a global shutdown on green card processing and many temporary visas in the wake of the pandemic, or using the pandemic and as an excuse. So unfortunately, this is all of one piece of, anti-immigrant white supremacist hostility on the part of this administration.
Yeah, and it's interesting to note that during the last campaign 4 years ago, Mr. Trump attempted to claim that he was a great friend of legal immigration. A lot of these things that we're talking about are basically trying to block legal immigration.
I just add, these asylum cases are life and death cases. And it's just really important that we preserve that tradition that has been such an important part of the country. And we've seen that the courts of appeal have meaningfully reviewed these cases, and building strong records with the immigration judges and the Board of Immigration Appeals have been really important in conducting smart and thorough litigation at the courts of appeals has been critical. And they have recognized these claims that this administration, through these proposed regulations, are trying to eliminate. And so this is really going to be a battle. And so comments opposing these proposed regulations are really important right now.
And on the other aspect of that, of the asylum cases, they've also, the administration adopted the rule about if you pass through another country on the way to the US border, then you can't get into this country for an immediate hearing on your asylum petition, and you have to apply for asylum in that country that you've passed through. Does anybody have any thoughts on, have you seen the Ninth Circuit decision from last week that basically said that was a erroneous, that was not a permissible reading of the, or permissible change to the law? Why don't we start with you, Judge? Have you seen that?
Yeah, the way the statute reads is if you are firmly resettled in a third country prior to coming to the United States, you're not eligible to apply for asylum. Well, passing through a country is not a firm resettlement. Firm resettlement is you're granted the right to live permanently in that country. You're given permanent resident status. The Trump administration says, no, if you pass through the country, you have to apply for asylum there. Well, many of these countries, Guatemala, Honduras, they don't have an asylum system.
Yes.
The people passing through cannot apply, and they've never been offered permanent resettlement, including the people passing through Mexico on the way to the United States. So they went outside of the statute, and they made up this, if you pass through a third country, you're not eligible. So it was just a matter of time for a court of appeals to say, that's not what the statute precludes. Now, of course, hundreds of thousands of people are still being sent back to Mexico. They're still implementing the policy. And, I think once a few other courts of appeal reach the same conclusion, and whether it goes to the Supreme Court, and if the Supreme Court says that is not a preclusion passing through a third country to asylum eligibility, then the administration will stop. But it's really, and that's only one example, that the MPP program, what's that called, Mary? The
Migration protection
or wait in Mexico, as
Yeah.
other people say.
Remain in Mexico, right?
Remain in Mexico. It's forcing people who are fleeing persecution, other than Mexicans, from other countries, to remain in Mexico in extremely dangerous conditions. And they've already documented, the attorneys at the border, the pro bono outfits have documented how these people are being attacked, robbed, sexually molested while they're remaining in Mexico to come to the United States border and present their case. So this is, again, another policy that has placed these people in danger. But the Immigration Act says that a person who arrives at our border has the right to apply for asylum. And the administration is just saying no. And so eventually the courts will have to step in, but who knows when that will be.
You know, I would just add the other challenge here to, you know, this recent Ninth Circuit decision, and then the DC District Court also found that, you know, the administration didn't implement this policy about asking for asylum in another country properly, is now we have clients who only applied for another form of relief called withholding of removal, and now who are entitled to go back and ask for asylum, or who were denied even access to the process under what's called a credible fear interview. So you now have people kind of in this legal limbo because the administration made such a mess of the process. These individuals should be able to go back and apply for asylum. And so we're trying to figure out how to best provide that opportunity for individuals who were denied. So we have a lot of work to do.
So I'm going to turn it back over to Carol to open things for questions or to provide some concluding thoughts. And if any of our panelists want to chime in with any additional suggestions they have about what we can do, and apart from, or in addition to posting the comments that we've already talked about, feel free to chime in with those as well. Carol?
Okay, well, the one question which was asking Fred for some clarification on the casing engine, and Fred answered that, so we got that taken care of. And I think, you know, we've had a really lively back and forth discussion, and there are some very clear actions that people on the phone can take. I think, I'm looking to see, we are put up in the chat box some information, and we will put more up and also send out information after this call about ways in which you can take action on the issue of asylum. And Mary Meg, is the information you sent me this morning, is that available also on websites?
Yes, it's on our website, immigrantjustice.org. And you can just type in asylum regulations, and there are model comments that people can use, both community members and lawyers, to express your opposition. And then it explains the process of submitting the comments, which again are due tomorrow. So
okay, yeah,
people to use the immigrantjustice.org website.
The urgency is that that's due tomorrow. So you have today and tomorrow to get your comments in. I did comments yesterday, and it was gratifying to see that comments were coming in at a very rapid pace, because I went back today just to see if there were more comments, and there were. So people should make comments. You can make your own, you can use ones that other people have made, but tell this administration that this is not something we want to see happen in the United States. This is not the way the United States functions. And this is one of the things that I want to say that is part of why Courts Matter Illinois exists. We want a judiciary that functions, that we don't have to keep going to fight these kinds of things. We want it to be there to support good law and good quality, with justices that are there who will uphold good law. So that's why we're here. We're here to educate people about these kinds of things. And often we will send people who sign up to be a part of Courts Matter Illinois. It doesn't cost you anything. And those of you on this call, if you've never been a part of us, we'll add your names to our list. If you don't want to be there, you just email us back and say, take me off the list. But you'll hear from us. You'll hear from us about webinars. You'll hear from us about actions you can take. And you'll hear from us on a weekly basis with just an update about what's going on in the federal courts. That's what we do. That's our job. That's why we're here. So in closing, because we're getting close to the end, I want to do some very heartfelt thank yous. And the first ones are to our panelists who have shared with us their wisdom and their insights, and really for the hard work that they do on the issues of immigration. So to Mary Meg, to Fred, to Bob, thank you. The work you do is outstanding, and it does make such a difference for so many people. And as someone who I know, I come from a background of immigrants who, I wouldn't be here if it were not for the policies of this country that allowed my grandparents to get here. So thank you. To David, who moderated so well, thank you, David. And thank you for all you do for Courts Matter Illinois. And to behind that screen that says Courts Matter Illinois is Mike, our one week into his new job, outreach coordinator. Thank you, Mike. You did a great job. Everything went smoothly. Secondly, I want to thank our sponsoring organizations again. We appreciate your support and just being there for us and helping us make this series, Courts Matter to the 2020 elections, move forward. Thirdly, I want to thank everyone who's been on the call and participated with us, and remind you that our third webinar in this series, Courts Matter to Voting Rights, will take place at noon on Thursday, August 4th. We have a great lineup of speakers from on voting rights, and I hope you'll join us. Information will be out in about a week on that, and I can assure you that will be a very lively discussion as we begin our efforts both in Illinois and we look around nationally. Remember that today is a primary day in some states with major COVID issues, and we'll see what happens there. We hope you all will join our Courts Matter Illinois family and advocate for a fair and just federal judiciary. Check out our Facebook page, email us at courtsmatterillinois@gmail.com, and please continue to remember that courts matter. We will be sending everyone this piece, which is Courts Matter to Immigration. It has lots of the information that we've discussed today. Remember that courts matter. Please vote. Thank you and have a great afternoon.
Thank
Goodbye,
you.
everyone.
Goodbye.